Welcome back to the PI show. Before the break, we were talking about superannuation and insurance benefits and matters that have gone to court. And I think the revealing thing is how the courts decide these cases. As you say, I think they adopt increasingly a common sense and realistic approach. The case that we're going to discuss is Jeffrey Baker. He worked for Borkum City Council in Sydney from, I think, 1999 to 2002, and then had an injury and stopped work and claimed that he was totally and permanently disabled.
This is a gentleman who worked primarily as a labourer. He was, his main duties were to ride a ride-on mower.
For the council?
Correct,
yep.
For the council. And on one day in February 01, his co-worker riding a ride-on mower struck a stone which shot up and hit him in the jaw. It broke his jaw, but it caused problems with his upper back, his cervical spine, and his neck as well.
So he had an operation
on both.
He ended up having
surgery on his face.
So he had significant injuries.
And then what happened was, in effect, he couldn't go back to his normal job as a labourer, but the city council then sort of looked after him for a little while. They gave him an alternate desk job.
They gave him a light duties job, working on a computer. But
he wasn't really suited to it.
He wasn't. He was suited. He was educated and trained as a labourer, as riding a ride-on mower.
They created a job for him, really, didn't they?
They did. They modified a suitable job to take into account his injuries.
And he had a lot of rest breaks, and increasingly, I think he found it hard to cope with that job. And eventually, the council said, "We've had enough. You're sacked." And shortly thereafter, he consulted a lawyer, put in a claim, and the trustee then denied the claim, saying, "Look, you're able to do alternate duties, therefore you're not totally and permanently disabled."
Correct.
Well, what did the court do in that case?
Well, I think this is a case, Harry, that demonstrates the difference between how a layman would consider the words total and permanent disability and how the courts interpret it. When one thinks of total and permanent disability, you think
you're almost like a vegetable.
You're in a vegetative state. However, the courts increasingly, and there is a string of case law on this, they look at what you're qualified to do, and if you can't return to generally comparable employment, then they consider you to be totally and permanently disabled, depending on the individual insurance policy that applies. But that's, as a general rule, what they look towards.
So this fellow had a problem in the open labour market. They created a job for him. They kept him there for a while. Then they sacked him. But in the open labour market, he was really not employable, was he?
Well, he wasn't.
And these policies generally look at a person's age, education, experience, and those sorts of things.
Taking a common sense approach to this, Tony, you're looking at what prospects does he have in the real world to return to work?
So, look, but Paul, he could do some work. He's not a total vegetable, but he's probably unemployable. I think the evidence in this case was once he was sacked, he did try to get work and was unsuccessful. So he'd been unemployed for quite a long time. And
the medical evidence actually adduced in court showed even his own treating doctors said he was coping very well with the office-type duties.
Well, I'm not sure about that. I think he was coping, but he increasingly, the way I read it, he was taking increasing rest breaks and gradually...
But it was a sheltered employment. I mean, he wasn't a productive worker. He was inefficient. In the open labour market, most employers just wouldn't look at a person like Mr. Baker. They just wouldn't want him there.
No, so...
Totally unproductive.
He just couldn't get a job.
No.
You know, and then he was sort of on the scrap heap, if you like. And the court said, look, in effect, you know, he can... he qualifies under the policy. He is totally and permanently disabled, and he succeeded. Paul, again, another case, again, New South Wales. We don't run many cases in Victoria, apparently, but New South Wales is...
Highly litigious in New South Wales.
Highly litigious.
There's been a lot more running
and the case of Mr. Halloran, and he sued, he worked for CSR in New South Wales, again as a labourer.
He was a factory greaser for CSR, a machine operator.
A machine operator. And then before he started with CSR, he'd done a lot of labouring work, and he didn't have any real qualifications, had an injury, and was unable to work. I think he took a redundancy package.
He sustained a fall at work when descending some steel steps and struck his lower back. He was off work for a week. He returned on some lighter duties and proceeded to keep working for about a year, but his back condition deteriorated to the point that he had to cease working about a year after his injury.
I think the interesting thing about this case was that Mr O'Halloran then, after he left CSR, enrolled in courses and did some education, and then was able to get some work about 3 or 4 years afterwards. But in my view, that wasn't permanent work, and then eventually he stopped that work. But he was able to work after he left CSR.
By virtue of his retraining at TAFE qualifications, he'd undertaken some training in computer courses, and he'd obtained a job at the Aboriginal Lands Council as a project officer.
But that didn't last, for a lengthy time. And I think the defendants went to court. They denied the total and permanent disability. Went to court. The defendant said, "Look, this person might have been totally disabled 6 months after he left, but he retrained and he got back into the workforce. And therefore, you've got to look at all the factors that of whether someone is disabled over a period of time." But that's not the approach the court took in this case.
Well, the court in this case, the relevant definition was when he was injured, what was he reasonably qualified to do? Qualified being a past and present tense at the date he was injured or the date he ceased work.
And 6 months thereafter, I think.
6 months thereafter.
Yeah.
However, he obtained this further job by virtue of retraining. So it was skills that he had yet to acquire within 6 months of the date of his last working for the first employer, so for CSR. So the judge in this case said that he had to be retrained to do that work with the Aboriginal Lands Council, and therefore the TPD definition here only allowed to be considered what he was qualified to do.
Well, Paul, it doesn't really matter. He was retrained. He had capacity to work. The judge just bent over backwards for him, really.
Oh, well, I think the judge adhered to the definition of the policy.
He took a strict technical interpretation.
Yeah, he got the plaintiff up, and the plaintiff succeeded in that case. And I think he said in some circumstances you can take into account subsequent events, but in this case he was going to ignore it.
Yep.
And 6 months after he left CSR, he was totally disabled, even though he got back to the workforce afterwards. So he got the benefit. That's all we've got time for. We'll be back after the break with some more material about superannuation.